Oh, well, hello there. Before I start, I really want to thank the stars that helped me make this video. Thank you so much.
Congratulations.
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 Marty, you must go back in time and learn the difference between the Indian Constitution and the Australian Constitution. The future depends on it. Doc, do I have to? Okay, I will. Be right back. Constitutional history in 2 minutes. Australia. The settlement. In 1770, Captain James Hook traveled across the world by sea. His journey led him to what is now the Australian coastline. He claimed the land as British territory since it was supposedly terra nullius. Responsible government. During the time period of 1867 to 1890, the Australian continent was divided into 6 separate British colonies. During this time, the colonies formed a rudimentary form of responsible government. Federation. During the 1890s, 2 constitutional conventions were called. These conventions required each of the 6 colonies to vote. The vote was eventually successful, and thus the Constitution had been approved. In 1900, the British Parliament passed the Commonwealth of Australia Constitution Act. India. Unlike the discovery of Australia, terra nullius did not apply. The development of India's constitution was heavily influenced by the British when they decided to settle on their land in 1858. It was not till 1946 when the British decided to grant India's independence. India's independence. On August 15th, 1947, India gains independence from British rule, and an assembly formally convenes for the first time to start writing a constitution. On January 26, 1950, the Constitution of India came into effect. So, who was the father of the Indian Constitution? The father of the Indian Constitution was Dr. Ambedkar. He was actually a Dalit, which means an oppressed person. The lowest caste, which are also known as untouchables. Because he was such a low caste, he knew how backwards the thinking of Indians were, which is how the central theme of equality comes into play under Section 15 of the Indian Constitution. It states that one shall not discriminate against any citizen on grounds of religion, caste, sex, or place of birth. The separation of powers in 2 minutes. Since Australia and India have a constitution influenced by the United Kingdom, it comes to no surprise that they share a similar structure. In both countries, there's the parliament, the executive government, and the judiciary. The parliament has the power to make and change law, whereas the executive government has the power to put law into action. And finally, the judiciary has the power to make judgments on law. The legislative. Like Australia, India runs on a bicameral system. The Australian and Indian legislative branch is made up of the House of Representatives and the Senate. The people of both countries elect their representatives in a fair, democratic election. The executive. The executive in both countries comprises of the Prime Minister and their cabinet members. Unlike Australia, the appointment of a Prime Minister is explicitly written in the Indian Constitution. Under Article 74 of the Indian Constitution, subparagraph 1, it states that there should be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advices. The judiciary. The judiciary is very similar in both countries. By the time of the creation of the Indian Constitution, Australia had 50 years of judicial elaboration of the Australian Constitution. Thus, the early decisions of the Supreme Court of India, India's highest court, substantially relied on decisions made by the High Court of Australia. Constitutional change in 2 minutes. Step 1. In Australia, for any change to occur, it must first be approved by the Parliament. Step 2. Once the proposed change is approved by Parliament, a referendum process occurs. Step 3. The Australian citizens then vote. A double majority must be met in order for a constitutional change. India. Step 1. An amendment can be initiated only by the introduction of a bill in the House of Parliament. Step 2. Once the bill is introduced, the bill must be passed in each house by a majority of the total membership of that house. Step 3. If passed, every constitutional amendment is formulated as a statute. This begs the question, is changing the Constitution in relation to the two countries easier or harder? Since 1950, there have been 101 amendments to the Indian Constitution, whereas in Australia, only 8 of 44 proposals to amend the Constitution have been voted on. Fundamental rights and implied rights in 2 minutes. Even though India's constitution was created in the 1950s, the concept of fundamental rights was embedded within Part 3 of the Constitution. We have India on the left and Australia on the right. In India, some of the fundamental rights are Section 14, the right to equality, Section 19, right to freedom. Section 19 has also 2 subsections of speech and expression and peaceful assembly. There's also Section 23, right against exploitation, and Section 25, right to freedom of religion. On the right, we can see that Australia has implied rights, which are Section 7, 24, 64, and 128. Together, this makes an implied right of political communication available for Australian citizens. In addition, Section 116 states that the Commonwealth will not legislate in respect to religion. In practice, do fundamental rights work? Let's do a case study to examine this.